You're watching the legal breakdown. So, Glenn, I'm not saying that Trump's desperation is showing here, but he's now filed a motion to recuse Judge Chutkan. That's from the DC trial. First of all, who will decide on this request to recuse, and what's the likelihood that Trump actually gets this thing granted?
Yeah, so in the first instance, the motion will be decided by Judge Chutkan herself. She'll have to decide whether she has the ability to be fair, to sit fairly and impartially and independently as the judge trying Donald Trump's case for attempting to overturn the 2020 presidential election. I will bet the full buck, as you know, that's my betting limit, on her denying the motion to recuse and concluding that she is impartial and nothing she has said or done gives anybody reason to question her impartiality. But then, of course, Brian, once she rules and denies the motion, Donald Trump's lawyers will file an appeal, and I have a feeling it will be resolved promptly by the appellate court, probably summarily and very quickly, and they will similarly deny it. And I can predict there is no chance that this will go up to the Supreme Court. It just simply does not involve a question of novel constitutional law or of constitutional law at all.
Now, just a quick question. If Trump does appeal and it gets rejected and he appeals again, the next appeal would be to the Supreme Court. So what happens in this case? When you say the Supreme Court won't rule on it, do they have to say something, or how does that work?
So what happens is, let's assume Judge Chutkan denies the motion. The DC Federal Circuit Court of Appeals upholds that denial, and they'll do it quickly within a week or two. Then Donald Trump's lawyers will file a petition in the Supreme Court asking them to review it. And I have a feeling the Supreme Court, literally within days or perhaps a week or two, will refuse to accept the case for review because there is no constitutional principle at issue here.
Okay. Now, Jack Smith opted not to request Judge Cannon recuse herself from the Florida case, and that was despite an obvious and noted conflict in that she interfered on Donald Trump's behalf. And yet Donald Trump did request that Judge Chutkan recuse herself from the DC case despite no conflict. What does that disparity say to you about the two sides here?
Brian, it says that each side is exercising their own judgment as they see fit. And frankly, I can question the judgment on both sides of this issue. Part of it to me feels like we are litigating in like Alice in Wonderland, where down is up and black and is white and in is out. Because if anybody has shown themselves to be biased in favor of or against the party, it's Judge Cannon down in Florida. And don't take my word for it. The 11th Circuit Court of Appeals ruled that she did something unlawful. She did something the law did not allow, and she abused her discretion and did an enormous favor for Donald Trump. Of course, the appellate court reversed her and told her she couldn't do it and she couldn't interfere in an ongoing DOJ investigation. I have to tell you, if anybody has distinguished herself as not being able to be fair and impartial, and somebody who really should remove herself from the case, recused from the case, it is Judge Cannon. But Jack Smith did not want to kick that particular hornet's nest. However, Judge Chutkan has said and done nothing comparable to what Judge Cannon did. In fact, she has said nothing that shows she can't be fair. She can't be impartial. She can't be unbiased. You know, they filed their motion, and it's about a 7 or 8 page motion, Donald Trump's legal defense team. And, you know, I've read it now forward and backward. Frankly, it's equally unpersuasive, whichever way you read it. But let me just do a 2-minute law school class here to try to explain why this motion will fail and why it is so unpersuasive. And it has to do with precedent. So most people understand that precedent is when a court, an appellate court, makes a decision. They author an opinion. They resolve an issue. And the way they resolve that issue can then be used and applied to other cases as precedent. But importantly, when the appellate court is resolving an issue, they look at a set of facts. They develop the facts, and then they apply the law to those facts, and they decide that the law requires that they rule either in favor of the defendant or in favor of the prosecution. but it really is the facts that are what's most important. Here is what precedent involves. The defense team, the defense attorneys representing Donald Trump, should have looked for any and all cases, any and all precedent where a judge said or did something similar to what Judge Chutkan said. And I'll talk about that in a minute. And if an appellate court took very similar facts and said, oh, what that judge said means that judge should have removed herself from the case. She should have recused because she can't be fair. Guess what? You can read this motion as many times as you like. There's not a single piece of precedent in it cited by the defense. They couldn't find a single case with a similar set of facts where an appellate court said, oh yeah, that's bad. And it's a lot like what Judge Chutkan said. So Judge Chutkan really should remove herself from the case. No precedent at all. Let me just read one sentence from the defense motion. This is the kind of thing they complain about. Judge Chutkan has sentenced many insurrectionists. Frankly, every judge in federal court in Washington, D.C. has sentenced many insurrectionists because there are so many cases involving people who attacked the Capitol on Donald Trump's orders. And here is what Judge Chutkan said at one of the sentencing hearings. She said to the defendant, you make a very good point. The people who encouraged you and rallied you to go to the Capitol and take action and to fight have not been charged. The issue of who has or has not been charged is not before me. I don't have any influence on that. I have my opinions, but they are not relevant. Can you believe that is the language that the defense picks up on? And they claim, oh, well, because Judge Chutkan said she has opinions, she can't possibly be biased and preside over Donald Trump's trial. That's absurd. This is a borderline frivolous motion, but that is some of the best language they can come up with. And that is why Judge Chutkan will not remove herself, nor will the appellate court order that she should be recused.
By the way, I would just add that on the issue of sentencing insurrectionists, I mean, Judge Kelly was a Trump appointee. He handed down the longest sentence of any insurrectionist. That's Enrique Tarrio, the leader of the Proud Boys. He got 22 years in prison. Again, that guy was appointed by Donald Trump himself. So I don't think this whole talking point that like being anti-insurrectionist is gonna land here. This is obviously all a delay tactic by Trump. How many more tactics can he deploy before he's forced to just accept his fate, which is that this thing is going to trial?
You know, the number of tactics, delay tactics that Trump's lawyers can deploy is really up to their imagination. How creative can they be? I will say at some point, the judge and the system and even the appellate court will grow tired of delay tactics that really have no basis in fact or law. So I will say this is a motion that can be filed. It's not a meritorious motion. It will be denied, in my opinion, but it's not like they made up a recusal motion out of whole cloth. They just don't have much factual support for it. I predict, though, they will file motion after motion seeking to delay the proceedings. I don't think they will succeed. Here's what I suspect will happen. When Judge Chutkan resolves this motion and refuses to remove herself from the case, and it gets appealed up to the the federal district court for the District of Columbia, the trial proceedings will not stop. It's not as if everything will have to come to a grinding halt because Donald Trump has deigned to appeal the recusal motion. So I don't think he's ultimately winning himself much by way of delay. I think the case is going to keep chugging along through federal court in D.C., even if Donald Trump does try to appeal some of these motions.
Can there ever come a point where the courts recognize that a defendant is just filing frivolous motion after frivolous motion and prevent them from filing any further motions? Or do the courts continue to have to avail themselves of these motions by these defendants, regardless of how frivolous they are?
Yeah, that's a great question. There is something called a vexatious litigant. When somebody files so many frivolous motions, courts actually can order that they will file no more motions. However, if there is a minimally meritorious motion, ordinarily the court will yield and say, okay, we will take up this motion. So I think the more usual way a judge handles a litigant who's playing games or who's just kind of nefariously trying to build in delay is they will look at a particular motion. They'll say, I've assessed it and it is summarily denied. Next. So they'll kind of give it a look, but they'll give it very short shrift if they believe there's no substance to it. And they're just trying to weaponize, filing motions to delay the matter.
Right. And it also doesn't really redound to Trump's benefit, because if he does at some point, which is unlikely, but regardless, if he does have a motion that is legitimate, it'll be kind of downplayed by virtue of the fact that he's cried wolf before and filed all of these frivolous motions to the point where, no judge is really going to take anything he says seriously because of what he's done over and over and over again. Let's finish off with this. Judge Maran, the judge overseeing the Manhattan DA trial, has now spoken with Judge Chutkan in D.C. Can you speak on that update?
Yeah, and Judge Maran just actually authored a letter and sent it to one of Donald Trump's defense attorneys. This letter has now been reported on, and it looks like Judge Maran is saying he is willing to basically have his March trial date yield and take a back seat to the D.C. prosecution of Donald Trump, which, of course, Judge Chutkan has set to begin with jury selection on March 4th. Yeah, if you remember during the last status hearing, Judge Chutkan said, by the way, I want everybody to know, I have spoken with Judge Maran about the fact that I intend to set Donald Trump's criminal trial in D.C. for the month of March. Reading between the lines, the two judges have communicated and perhaps even coordinated on the sequence of the trials, and all indications now, including this new letter from Judge Maran to one of Donald Trump's defense attorneys, seem to suggest that we will have a March trial in D.C. for Donald Trump's attempts to overturn the presidential election. And then in the future, Donald Trump will be prosecuted in New York for falsifying business records. And those are crimes involving his attempt to bury deeply damaging information from the voters in the 2016 election. So again, trying to steal that election from the people.
Which means if everything goes according to the plan that we're looking at right now, we can see the March trial for the DC case. We'll see a May trial for the Florida federal case. And we could see, that would free him up May, June, July, maybe a July or August trial for the Manhattan DA case, which, by the way, would probably be a good thing because a lot of people did take issue with the fact that what seemed like the least significant case relative to what we're seeing in Florida and in DC, the least significant case would then go last. And so it would kind of just be kind of extra as opposed to the principal trial that all of the other trials build off upon.
Yeah, and Donald Trump's prosecution dance card could not be fuller at this point.
Yeah, I think he gets one more. He gets a free coffee at the end of this. So with that said, for anybody watching, if you want to stay on top of this stuff, make sure to subscribe. The links are right here on the screen. I'm Brian Teller Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.